too, and I think we're gonna start now. So, all right, can everybody see my screen?
Yeah, good to go.
Okay, great. All right, hi everybody, and welcome to week 5 of our family law school for self-represented litigants. My name is Emily, and joining me tonight is River, as well as Rachel. So we're going to be speaking about fee waivers in BC Supreme Court, as well as family violence tonight. So before we get started, we're just going to go through our regular housekeeping and other slides. So let's see here. All right, so before we start, I just want to make a territorial acknowledgement. Today, actually, I'm joining from the traditional, ancestral, and unceded territory of Kamloops to Shikwat people, so otherwise known as Kamloops. And also, I know there are some people joining us tonight from the traditional, ancestral, and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh nations. So I just want to take a moment to acknowledge our privilege that we have to learn and work and play on this land and on this unceded territory, as well as acknowledge the role that lawyers have played in our colonial past and the role that we have to play in truth and reconciliation going forward. So just taking a moment to reflect on the territory that you're joining us from today. And if you'd like to, you can just pop that in the chat as well. So the Family Law School for Self-Litigants is run by an organization called AC Friends of Court. We're a nonprofit organization that began in 2011 with our first legal forms workshop being held in the offices of the Access Justice Center located in downtown Vancouver. And our legal forms workshops help British Columbians access affordable legal help for a variety of legal areas. Right now, actually about 45% of our clients are family law clients, and our Family Law School is the first program of its kind, which we're very excited about. I'd also like to acknowledge tonight that the School for Family Law Self-Litigants would not be possible without the generous contributions of Kylene Wong, who is a lawyer at Black Gropper, Don Bautista, who is the executive director at AC Friends of Court, as well as 2 individuals from the National Self-Represented Litigants Project, Dana Cornwell, who is their project manager, as well as Andrew Pillier, who is the director of the National Self-Represented Litigants Project in Western Canada. We also want to acknowledge that some of our work is adapted from resources that were originally developed by the Justice Education Society, the National Self-Represented Litigants Project, and Legal Aid BC. We also want to just reiterate that we do not provide legal advice during these sessions. They're only for providing legal information. And just to make sure that everybody is aware, we're just going to go over the difference between legal advice and legal information, because sometimes it can be a very fine line. So legal advice is generally when you're asking a question or providing information that is very specific and directly linked to somebody's legal case. So yeah, here's an example. So my ex says that because I moved out of the house, I'm no longer legally entitled to rights of the house, and I'm never going to get any kind of payment from the house. Is that true? That is legal advice because it's very specific to that person's situation. So if we provide answers to those questions, we'd be providing legal advice. So we don't actually, in our sessions, provide answers to questions like that. And if we do see them in the chat, we will not be answering them. However, we are very happy to provide legal information, which is more generic. It's not specifically linked to anybody's case, not providing any specific facts about your circumstances. So yeah, for example, I want to start a family court action in Supreme Court. what form do I use and where can I find that form? Or the difference, between guardianship and parental responsibilities. Those are the types of questions we would be happy to answer in the Q&A portion, as well as in the chat box. So if you have any questions like that, we'll be happy to answer them at the end of our session today. And then, of course, housekeeping. If you've attended a session before, you know that sessions are recorded and emailed to registrants afterwards. Just a reminder that everything is being recorded, and we also have reference materials, and we would greatly appreciate if you did not distribute those without our permission. We work really hard, and I know our speakers also work really hard on their presentation materials, and distributing those without other people knowing or without their permission kind of devalues that kind of work. And then if you haven't already sent in your participation agreement, please do so. Our email is just at the bottom of the slide here. If possible, please do mute your mic, and you can feel free to turn off your video. Questions, as per usual, go into the chat box, and we'll answer them at the end of the session from 7 to 7:30. And then again, keep the details of your case private. We're not able to provide any legal advice, so if you share a lot of details about your case, we will not be able to answer your question. And please respect others when communicating. That includes all the volunteers as well as the speakers tonight, and other participants. And of course, if you have any questions or concerns, you can email us at info@litigantschoolbc.com. And just one more reiteration of the last slide. Please do respect speakers, AC volunteers, and staff, as well as other registrants. Any kind of abusive or harassing language or behavior inside the chat box or during our session tonight is not going to be tolerated, and we will remove individuals who engage in that kind of behavior. So please be respectful. And without further ado, we're going to speak a little bit about fee waivers today. So the plan for today is that I'm going to speak about fee waivers for about 30 minutes, and we're going to take a 10-minute break, and the lovely River is going to speak about family violence afterwards until about 7 o'clock. And then after that, we're going to go through the Q&A portion of the session and answer any questions that you have in the chat box or that you want to ask as they come up during that time. So if you do have any questions, feel free to pop them in the chat box as we go, and we'll look into them at the end of the session. So yeah, I'm just going to do a little bit of an introduction now to fee waivers. So in BC Supreme Court, if you have started an action, so if you filed a notice of family claim, or if you filed anything else in BC Supreme Court, you might be familiar with something called filing fees. This is the amount of money that it costs to essentially submit a document to the Supreme Court. So those are the most common fees in BC Supreme Court, especially for family law. So there are fees for filing documents. For example, I think a notice of family claim might be around $200 now, or $210 to file. So it can get quite costly to file documents. And the other thing that they charge for in BC Supreme Court is swearing affidavits. Last time I checked, it was $40 to have an affidavit sworn at the Supreme Court House, a BC Supreme Court registry, I guess, in BC. So the other thing is some types of court record searches might cost money. If you photocopy anything at the Supreme Court registry, it will cost you $1 per page to obtain a photocopy. So it can be quite costly as well in that regard. Also, if they issue certain documents, for example, if you get a divorce, you can ask to get a certificate of divorce, and that does cost some money as well. And there's a very detailed table of all of the different fees in BC Supreme Court if you go into Appendix C of the Supreme Court Family Rules. So again, all the fees will be different. Filing fees are the most common, especially if you're applying for divorce. This is also something you might want to note, is that there are filing fees in BC Supreme Court for family law, but not in BC Provincial Court. Of course, we're only covering BC Supreme Court in this family law school. So, but just FYI, if you are interested, provincial court is essentially very low cost. I would almost say free. So in BC Supreme Court, there are ways to get these fees waived. So that would mean that the cost of filing a certain document or all of the documents in your court case would be free. So there's two types of circumstances where you can apply for a fee waiver. The first one is if you receive certain government benefits. So if you receive income assistance or benefits, sometimes people say, oh yeah, I receive PWD benefits. So any kind of benefits that fall under the Employment and Assistance Act, as well as under the Employment and Assistance Act for Persons with Disabilities Act. Those two types of government assistance or government benefits essentially will almost automatically qualify you to have your fees waived in Supreme Court. The other thing that you can do if you don't receive any of these benefits is you can say that you have undue hardship. So if you are in a circumstance that it would cause you to be or cause it to be very financially difficult for you to pay court fees, filing fees or otherwise, then they can also waive the fees for you and you will be able to go to court for free or for a very low cost. So in family law in BC, the word undue generally refers to something that is exceptional, excessive, or disproportionate. So when we talk about undue hardship, it means that paying any kind of court fees would be exceptionally, excessively, or disproportionately difficult for you financially. So now I'm just going to go over the process for applying for a fee waiver. So generally you need 3 different forms. The first form is called a requisition. It's form F17. The next one is called an order to waive fees. It's form F85. And the last form you need is form F86, which is an affidavit in support of an order to waive fees. So those are the 3 forms that you'll need for sure. The other form that you'll need is whatever document it is that you're trying to file without fees. So that could be a notice of family claim, which is form F3. It could be a counterclaim, form F5. It could be a response to family claim, which is form F4. Or it could be a notice of application, which is form F31. There are also a few other forms as well that have filing fees, but those are the most common ones. So you're going to need a copy of that, the completed version of that form. And you will also need a few other things. So one thing to remember is that an affidavit needs to be sworn. So that means you should bring photo ID with you to have it sworn. So wherever it is that you go to get your affidavit sworn, make sure you bring photo ID or some sort of government, well, actually, yeah, some sort of government issued photo ID is best. Otherwise, they won't be able to verify your identity and it could be an issue for the affidavit swearing. The other thing is you want to have proof of your estimated monthly expenses and income if you have those available. I would recommend it. It's not necessarily mandatory, but I would recommend it. It's better to have that information than to not have it. The other thing is if you receive government benefits, you're going to need a statement from the Ministry of Social Development and Poverty Reduction. And that statement needs to confirm how much money you receive in benefits every month, and also which months you've received benefits. If you've received benefits for a very long time, you just want to show, well, I've been receiving benefits on an ongoing basis, or I qualify to continue receiving benefits. And then, yeah, so I do have a tip for this. If you are looking to get a statement and you do receive government benefits, contact whoever it is that is helping you with that. So the financial assistance worker on the other side will actually be able to help you get a copy of that statement. So yeah, if you aren't able to find one yourself, then I'd highly recommend getting in touch with that worker, and they're more than likely able to help you. So now I'm actually going to go through the different types of forms. So The forms are things that you can find in a PDF version on the BC Courts website. And when you download them, you will actually see something kind of, well, actually, it depends on how you download them. Okay, this is a weird tip for and if I don't know if anybody said this before in the law school, but you do need Adobe to read the forms. If you download the forms in any other kind of application, if that's, Google Chrome or Internet Explorer, anything like that, it'll actually look like it doesn't load. It'll say, please wait. And then there's a bunch of text at the bottom. You won't actually be able to see the form. But if you open it in Adobe Reader, you'll be able to see the form. So what I'm going to do is actually walk everybody through the different forms and how to fill them out. It's actually pretty simple, but if you don't know what to put in the forms, it can be kind of confusing. So, or at least I know it was for me when I first started. So, as I said, so if you open a form from BC Supreme Court in Adobe Acrobat, it's going to look like this. So this is a form F17. So it's the first form you're going to need. It's a requisition. And I've kind of filled this one out here. So on the top corner, you're going to want to write the number of your court case. If you have no number and this is the first form you're ever filing in this court case, then you can just leave it blank. You also want to put in which registry you're going to go file at, and I'll cover that a little bit later. Your name and the other party's name, depending on who's claiming what and who's responding. Here, I just put myself as the claimant, and of course I put Ned Flanders as the respondent, because why not? And then you can also add additional parties. This is not very common in Supreme Court or in family law, or yes, Supreme Court family law, but it is an option if you do have a third party. The other thing you're going to want to do is put in your name. So it's filed by you. I put Emily Q just because I don't want to disclose my last name, but you would want to put your full legal name here. And then the trick is to put required. So when you fill out the form, it's really important that you fill out the required section. And in the required section, you want to write, file an application for an order to waive fees. So the purpose of a requisition is essentially to ask the court registry to help you do something. So we're just requesting them to file your application here. The other thing you're going to want to mention for sure is your affidavit. So we're going to cover this in a few minutes, but essentially this is going to be whatever affidavit number your form F86 is. So whichever affidavit number that is, I put number 1. Some people it'll be number 2 or number 3. Just make sure you number it correctly, and then made on whatever date you swore or affirmed the affidavit. And then after that, you want to print it out and sign it. So that's the requisition. Make sure that you bring one. Sometimes they won't let you file if you don't have a requisition. So it's I'd highly recommend it. Just make sure you bring a requisition with you. The next form you're going to want to fill out is form F86. So that's the affidavit form. Again, you're just going to, they have a lot of helpful drop downs. You're going to want to fill out all the information. Make sure you put your full legal name, as well as the date that you're swearing or affirming that affidavit. If you're not going to swear or affirm the day that you're printing it, just leave this blank. Whoever is helping you on the other side, so the commissioner or a court clerk is going to be able to write that in by hand. So I'm not actually 30, but you want to make sure that you answer all of this information to the best of your ability. So whenever you're making an affidavit, you want to make it short and concise. Not too much information, but you also need to fill out all of the information. So for example, here I wrote, I don't have the following dependents, but say you had a child that was, 5 years old. You would write their full legal name, And then you would leave it at that. So that would be somebody that you're financially supporting. Otherwise, I'd recommend you put none, just so that people know it's not left blank by accident. The other thing is if somebody contributes to your household expenses, so if they help you pay the rent, if they help you pay your bills, you want to make sure that you're listing that person there as well. You know, whatever their full name is, you want to list it there. Again, if you're not going to fill out a section of the form, make sure you put none, or write not applicable or something like that. If you leave it blank, sometimes people think you left it blank by accident and they won't let you file a form. The other thing is, okay, so if you're employed or unemployed, you want to check the correct box for that as well, because you'll have to provide different details depending on whether you're employed or unemployed. And the other thing that you're going to have to check the right box of is here, number 7. This one's very important. If you are not receiving any benefits, do not check the benefits box. You will have to submit different documents if you are receiving benefits versus if you are employed or are otherwise making an income. Or even if you're unemployed and you don't have an income right now, if you're not receiving benefits, do not check the benefits box. So I'm just going to show you what happens when you click a financial statement. So this is anybody who doesn't receive benefits should click this little box here. So this is going to actually add a different page to the form as Exhibit A. So this is Exhibit A if you are not receiving benefits. And this is where the proof of your income comes in handy. So if you do have a most recent pay stub or you have something else, you're going to want to attach that. You don't have to, but I would recommend it. It kind of helps it fill in some gaps in case the judge or master has questions. And then you want to fill all of this into the best of your ability. One of the questions I get very often is, how specific does this have to be? Do I need to put down, $100.01? Or like, is the court gonna think I'm lying if I put, $100 and I don't put the cents? Or if I say, it's $100 when it's actually $101? The answer is no, they're gonna be fine with it as long as you can estimate how much you are earning and how much your expenses are relatively accurately, then you should be okay. Now, if you're saying that your expenses are $1 million a year, you might have a little bit of an issue because that's usually not the case for most people. And in that case, you definitely want to be attaching receipts. But otherwise, if you can just give a general ballpark figure, that's usually okay. And you don't have to attach receipts that you don't have. The other thing is assets. A lot of people ask, well, do I have to disclose all of my assets? What if I don't want somebody to know I have a savings account? What if I don't want somebody to know I own a house or I own a car? This is an affidavit, so you do have to disclose what your assets are and what the estimated value is. Again, it doesn't have to be perfect. It doesn't have to be to the cent or even to, a perfect dollar amount, like $146 is, in my piggy bank. That's okay. But you do have to be honest with the court, and I would not recommend hiding any of your assets. So these are things that you have to fill out, or this Exhibit A are things that you have to fill out only if you're not receiving benefits. So everybody who doesn't receive benefits will have to fill this part out, which is, I guess, why I said before that you need to make sure you check the right box, because if you check proof that I receive benefits, you won't have to actually fill out all of the stuff that I just mentioned. You won't have to provide those receipts. You won't have to provide that proof of income. What you'll actually just attach is that statement that I mentioned before that you got from the ministry that shows how much you receive every month and how many months you've been receiving it for. So that will actually replace everything that I just went over. Otherwise, everybody else does Exhibit B, C, and D. They're all the same. So Exhibit B is a description of your education employment history. So I'll just scroll down and show that part as well. So you want to be, again, brief, but you don't have to put in too much detail. So say you have a bachelor's degree in fine arts. You could say that, or you could just say bachelor's degree and then you completed it in whatever year. Same thing with your employer, with your position, as well as the dates here. So lots of people will also get tripped up on, oh, well, I don't know the exact date that I started working there or the exact date that I didn't stop working there. I just recommend using months and years. Usually that's sufficient. And if you don't have the month, even the year to the year will be sufficient most of the time. You don't have to attach any kind of records for your education or employment history. You just need to state it in the affidavit. So there's no kind of attachments that you have to add here, unlike the first part of the affidavit. And the last thing you're going to talk about is workplace skills as well. And again, this is just generic. I find it really helps if you look at your resume and you're like, oh, well, this is what I did from this day to this date, and these are some of the skills that I have. And again, you don't have to write, a 5-paragraph long essay on what your workplace skills are. 2 or 3 lines, 1, 2 sentences will be fine most of the time. The other thing that's really important about the affidavit is that you need to attach a copy of whatever document you want to file without filing fees. That will be Exhibit D. And I only say this because I've made this mistake of forgetting to attach that document, and the registry goes, well, what are you trying to file? That's a good question. I didn't attach it. Make sure you attach whatever document it is you're trying to file without filing fees to the end of this affidavit. Otherwise, they will be confused and you will have to go back and refile. So that's that. And as with any affidavit, do not sign it before you are in front of somebody who's going to help you commission it. Don't sign it until you're in front of a commissioner, in front of a lawyer, a notary, or the registry clerk that's going to help you swear or affirm the affidavit. And then the last form you're going to need is something called Form F-85, and that is the order for a fee waiver. So again, your name, the other party's name. This part is a drop-down. So you can actually leave this blank. I accidentally clicked it, but I'd highly recommend just leaving it blank because usually you don't actually know if you're going to be sitting in front of a judge or a master or what their name is. So I actually usually leave this portion blank. And when you get to the courthouse, whoever's going to sign the order or the registry, if they know the schedule for that day and who is actually hearing these applications, they will write in those details for you. So don't worry about filling out who's actually going to be hearing you. If you don't know yet, you can just leave it blank. The other thing is there's a drop down here as well. So this part also I find can get quite confusing for people. The first option coming before me on date, and it will automatically fill for you these parts of the form. This is the option you want to choose because you're going to be appearing in court for a hearing, and whatever date that is just going to be written in by the registry clerk when you're filing. So make sure you're choosing this option. There's also another option for coming before me on date and on hearing. That would be if there's 2 parties, you and somebody else who are both applying at the same time. That's very unusual, and most people don't use this this line. And then the other thing is some people choose to try and get a fee waiver without going to a chambers hearing. Well, it is possible. I haven't seen it. Usually the judge wants to know why you're applying and wants to know a few more details from you in person. So again, even though this is an option, I wouldn't recommend choosing it unless you absolutely had to and you were 100% confident that you could get that fee waiver without providing any kind of additional details. So the most common one, again, that I see is coming on before me on whatever date the registry will give you, and then on hearing, and that will be your name. The other thing is number 4. So in a court order, this is essentially what the court is allowing you to do after your application. So there's also a few options here, which I find can lead to very different outcomes. By default, most people will choose in relation to this family law case, because that would mean that all of your filing fees, all of your fees in general are waived. So that means if you file 10 forms, it doesn't matter, it's still going to be $0 for you. There are other options in relation to the following parts of this family law case, which would be waiving the fees only for certain things. In relation to this family law case during the following periods, say, you're not going to have an income from July 2024 to December 2024, you would put that in there. And most people don't end up with an order like this. And then in relation to the following steps, so this would be, in relation to filing the notice of family claim, then that would be waived and the rest of the fees you'd have to pay. So most people will just choose in relation to this family law case, it'll waive all of the fees that you're applying to waive. And generally there won't be any exceptions. And of course, if after you appear in court, the judge or master decides that they want to have a different order, they will write that in. So don't worry too much about what you're choosing. Like, oh, well, what if they think that I should only pay this fee, or they think that I should only not pay that fee? If they feel like they need to make an exception, they will. And so if you want to apply broader, in relation to this family law case, is generally the best option because you're covering all your bases. And if they want to make an exception, they can. So those are the family law forms that you're going to need for a fee waiver. All right, so what should I file? So after you fill out all those 3 forms, you're going to want to take the originals and 1 photocopy of each document to the courthouse registry. And that includes as well the document that you want to file without filing fees. Make sure you're attaching it to your affidavit, Form F-86. Also, where should you file? This depends on what part of the legal process you're in. So if you're starting something in Supreme Court and you haven't started a case yet, you're going to want to file your application to waive fees at the registry that's closest to you. So this is if you're trying to file a notice of family claim, or in some cases a notice of application without paying a fee, and you don't have a family law case already in BC Supreme Court, then you're going to file at the registry nearest you. Otherwise, if you already have a case started in Supreme Court, so if you're going to file a response to family claim, you're going to file a counterclaim or a notice of application where you already have a file number for your Supreme Court case, you want to go back to the registry where that case was started. Or you want to go to the registry where that case will be heard if you're transferring registries. And that'll be on the top right corner of whatever document started your case. Usually it's a notice of family claim. It'll say filed in XYZ registry. That's the registry you want to go to because they already have all of the files and the information. Again, as I was saying, another common question I get is, do I have to appear in court? Is it possible to get a fee waiver without an appearance? And the answer is, it depends. As I was saying, most people do have to appear in court because usually the master or judge wants to ask you a few questions about your income and expenses and your financial situation before they give you the order. However, if you are 100% confident that your affidavit gives enough evidence that they will grant you an order without having to hear you in court, then you can feel free to try and apply without for an order without a hearing. Again, that's pretty rare from my experience, but it is possible in very limited circumstances. So I'm just going to talk a little bit about appearing in court, because usually when people apply for fee waivers, this is the first time they actually appear in court in their court case. So one thing is, how do you know when you're going to appear in court? So how do you schedule a court appearance date? It really depends on what courthouse you're applying in. So for example, Vancouver Courthouse has judges that hear, or masters that hear applications every day. So sometimes you can go into the Vancouver Courthouse registry, say, I want to apply for a fee waiver, file your documents, and they'll say, yeah, go upstairs and we'll hear you right now. Whereas in smaller registries, you might actually have to book a week or two in advance. So it really depends. I'd highly recommend just asking the registry clerk what days are available, and they'll usually tell you, here's the dates and times. You choose one that works for you, and the clerk is just going to write whatever date it is on the order form that you're filing. So that's when you're going to appear. Something else is, well, what do you say in court in a chambers application? So when you appear in court to ask for a fee waiver, there's kind of a bit of a formula to it. It's generally the same thing every time. So you're going to address whoever it is that's hearing your application. It's either going to be a judge or a master. Judges go by Justice, Chief Justice, or Associate Chief Justice. Masters go by Your Honor. So if it's Justice, whatever, you're going to say Justice, whatever their last name is. And then you're going to tell them your legal name. You want to tell them that you're not represented by a lawyer, what you're applying for and why, and which documents you filed for your application. So in order, it'll sound usually something like this. My name is Emily Q. You'd say your full last name. I'm not represented by a lawyer. Or some people will say, my name is Emily Q and I'm self-represented. Either one is fine, as long as they know you're not a lawyer and you're not being represented by one. And then after that, you'll say something like, I'm applying to the court for an order to waive fees. So that's what you're applying for, and then why you're applying. So I can file a notice of family claim for a divorce, is an example. And then after that, you're just going to say generally what you filed as evidence to support your application. So you would say, I filed an affidavit that sets out my financial position, and it includes information about my income and expenses, as well as my ability to earn an income. So that's Form F86 that we went through earlier, with all of the financial details. That's generally all you need to say. And then the judge will ask you a few questions, and they'll grant you the order, or they'll decide to not grant you the order based on the information that they have. So here are my tips for chambers appearances for the first time or every time. So the first thing is arrive early. If you are scheduled to appear in chambers at 10, arrive at 9. If you're scheduled to appear in chambers at 11, for example, I actually think the court takes a break then, but say you are in some alternate universe, make sure you arrive at 10. Try to arrive early. And that's because chambers applications are really different than a formal court trial. You'll go into a chambers courtroom. There will be quite a few people there, generally speaking, and they're all there to make an application. So there might be a few people before you or a few people after you. And when you go, or when when you actually end up going and making that appearance depends on how fast everyone before you has gone. So some people will be way faster than the time they're scheduled for. Some people will take way longer than the time they're scheduled for. Always arrive early so you don't miss your spot. Otherwise, you will have to rebook or you'll have to come back the next day. The other thing is always plan to spend more time in court than you expect. So again, whenever you appear in chambers, it really depends on who's going before you. If they take longer than they're scheduled for, then you might be there for a few more hours than you thought you'd be. Sometimes people will be scheduled for the morning in chambers and they won't end up going until the afternoon, really late in the day. So if you are taking a day off work or if you're paying for parking or whatever it is, make sure that you're planning to spend more time in court than you actually expect. The other thing is make sure that you're checking in with the clerk when you enter a courtroom. So whenever you enter a courtroom for chambers appearances, there's going to be somebody sitting at the front, usually at a desk. It's a little bit below the judge, where the judge sits, and they'll be on a computer. That's the clerk. Make sure that you're going up to them and checking in with them. Tell them what your name is, tell them that you're self-represented, and tell them what time you're scheduled to appear. That way they'll know that you're there and they'll actually call you when it's your turn to go. If you don't check in with the clerk, they might not know that you're there and they might not actually call you. You might miss your turn and you might have to reschedule or come back the next day. The other thing is courtroom manners. So if you're going into a courtroom and there's already a judge or master inside, you want to make sure that you're bowing to them when you go inside and bowing to them when you're leaving the courtroom. If they're not actually there, you can go in, you can have a seat, and usually when they come in, everybody will stand up, bow, and sit down after they've sat down. The other thing is, it can be really nerve-wracking to go into court for the first time. I know it's also really nerve-wracking for lawyers and law students to go into court, and they do it a lot. So I think one good tip is, if you don't know where you're going in the application or you feel like you trip up, just let the judge or the master guide you through. They know what questions they want to ask. They usually know what information they're looking for, and they'll ask the questions that they want to ask and guide you through that application process. If you don't know what to say, just say, I'd be happy to answer any further questions. And usually they'll have further questions or they'll just say, nope, that's everything. So just let them guide you. They're usually pretty good about that. So yeah. Something you might hear in court is a judge, after you made your application, they'll say, take your order. That just means that your order has been granted. It's kind of a weird phrase, so I thought I'd pop it in there. I wouldn't know what it meant a year ago. So it does mean that your order is being granted. And if your order isn't granted, usually the judge or master will tell you why. They'll say, I'm just not convinced that you are facing that much financial hardship or that you can't pay for these court fees. I'm just not convinced on the evidence. They'll tell you why they're not granting the order usually. The other thing is, if you're ever in court and there's a break, the courtroom is locked. This has happened to me before where I forgot something in the courtroom, then there was a break, and all my belongings were just locked in the courtroom during the break. So they do lock the courtrooms. Make sure you're taking everything with you whenever you leave a courtroom. Always double check before you leave because they do lock those rooms and they will not unlock them until the break is over. And the other thing is, inside court, you will likely see clerks or the registry staff or sheriffs. If you ever need help or directions, just approach court staff. Usually they're really nice about it. They'll point you in the right direction if you're looking for a specific courtroom. If you have safety concerns, you can always go up to a sheriff and say, hey, I'd like to be, escorted to this courtroom, or I need help. I have a concern. My ex is here unexpectedly and I need, I feel unsafe. I'd like to be escorted somewhere. And usually they're really good about that as well. So those are just my quick tips for chambers appearances. If you're making a fee waiver application, it's usually going to take about 15 minutes. So it's pretty quick. It's kind of a one and done usually. So yeah. And that's everything about fee waivers for now. And what I think we're gonna do is we're gonna take about a 10-minute break, and then River is going to start on family violence. So yeah, if you want to just take a walk
I think
or
that if we actually just for the schedule, I think,
for the schedule. Okay.
yeah, I think it's only a couple minutes that we have until we want to get River talking. So maybe just a couple minutes to grab a cup of water, and then we can get everybody back so we could
Sure.
go and get started for 6:20.
Yeah, sure. Let's take a 2 or 3 minute break, and
2 minute
then
break just to grab some water. Yeah.
grab some water, grab a snack, go to the bathroom, do what you gotta do, and then we'll see everybody at 6:20-ish. Okay.
Okay, perfect. Hi, everybody. It's 6:20. Hopefully, you had a quick chance to have a snack or grab some water, but we're gonna get right started for the family violence section. So I'm gonna pass the reins over to River, and they'll do the presentation there.
All right. Am I coming through okay? Folks can hear me? Wonderful. And thanks, Emily, for that presentation. That was really wonderful. In particular, I really liked the comments on just appearing in chambers, speaking to the court. That's just wonderful advice for anyone.
Thank you.
I'm going to share my screen. There. How's that? Is that nice and visible for folks? Yes, perfect. Okay. So I think, as Emily and Rachel mentioned, I'm going to be speaking about family violence today. It's a pretty big topic, and I don't have all that much time. So it's going to be sort of a brief overview and introduction to how family violence is defined and treated in British Columbia, in Canada more broadly, but most importantly in the courts of British Columbia. Just a couple words about who I am. And you'll have to pardon me, I tested positive for COVID yesterday. So I'm alive, but my voice has suffered a little bit. I have been practicing law in the province since 2018 as a staff lawyer for the YWCA Metro Vancouver. I host free workshops on a broad range of legal issues through the Y. And I also do advocacy work for change in our legal system. I do offer free legal help to residents of YWCA housing, and at this time I don't take private clients or anything like that. All of my work is through the YWCA and its programs. I also serve on the board of AC. I'm really, really lucky to do that. And I'm also on the board of West Coast Leaf, which advocates for gender equality in British Columbia and in Canada. I just wanted to start with some statistics because before we talk about family violence, I think it's important to situate it within its context as gender-based violence. So 48% of homicides that were solved in 2015 involved a female victim and were committed by a spouse or intimate partner. Sorry, that's 48% of solved homicides involving a female victim were committed by a spouse or intimate partner, and 22%, an additional 22%, were committed by another family member. And that's very different than men who are mostly victimized by people they don't know. In 2021, 127,000 victims of police-reported family violence were essentially noted by law enforcement. So that's police-reported family violence that's taken seriously, recorded by the police and authorities, and not taking into account all of the victims of family violence that don't reach out to police or where police don't make a note of it. And so that number is likely much higher. Even so, in 2021, that was the 5th consecutive year of increase. So it's getting worse year to year. And there was a huge increase in 2020 with people being stuck at home because of the pandemic. 69% of family violence victims or survivors identify as women and girls. So it's not all. There are men and non-binary people who report being survivors of family violence or who have to deal with family violence as they move through the family system. So it's important to note that, but that this is very much an issue of gender-based violence. Angela Marie McDougall, the executive director of Battered Women's Support Services, noted, I think really strongly, that for every woman killed, for any statistic that's reported by the police, there are so many more women who are living in fear, either within relationships or struggling to deal with an abusive ex-partner outside of the relationship after separation. However, it's important not to lose sight of the fact that the provisions of the Family Act relating to family violence are not intended to punish people, but rather to address a serious social issue, that of gender-based violence, and to protect children and spouses from actual harm or danger. So the tools of the Family Law Act that deal with family violence, or the Divorce Act that deal with family violence, are intended to try and keep people safe and move families towards healing. And they should not be used as a weapon in a financial war or a war over assets, as can sometimes happen in high conflict family cases. So breaking this down into the topics I want to discuss tonight, hopefully we'll have time to get to all of them. Maybe Emily or Rachel can warn me if I'm getting short on time. The first is just to define what family violence is and what it's considered by the laws of British Columbia. The second is to talk about family violence in the framework of dispute resolution, whether that's mediation or other forms of out-of-court dispute resolution. Then I'd like to talk about family violence and how it's dealt with by our court system. And then lastly, I want to talk about some general tools and strategies people can employ, whether they're a survivor of family violence or someone is accusing them of family violence. What can they do about it in practical terms? So defining family violence. Family violence is defined in both the Family Law Act and Divorce Act, and the provisions are relatively similar in both. The Divorce Act applies only to married couples, whereas the Family Law Act applies to all couples in British Columbia. Family law violence in both of these acts is a really broad definition. It does include physical and sexual abuse. That's what most people think of when they think of family violence, being hit by a partner or being sexually abused or coerced by a partner. But it also includes psychological or emotional abuse, including intimidation, harassment, coercion, unreasonable restrictions on financial or personal autonomy. And I want to talk about that later. Financial abuse as a particular category of family violence that is underreported and that is not dealt with as often as it should be. Stalking, property damage, whether a threat to damage property or actually damaging property, and indirect exposure to family violence in the case of a child. That's another important category that I think doesn't get enough attention. And I think many lawyers don't really think of it. But child witnessing family violence is itself a form of family violence that the court should be responding to. When talking about family violence as it relates to children, there are factors that are set forth in the Family Law Act at Section 38 that are really helpful for thinking about how to talk about family violence to the court, or how to think about family violence in terms of solutions, right? So these factors are the nature, seriousness, frequency of the abuse, whether there is a pattern of coercive and controlling behavior. And I want to talk a little bit more about this shortly, coercive and controlling behavior, which is kind of strange language, but it's becoming more and more something that can be discussed or brought to the court's attention in a way that I think is ultimately very helpful to survivors. Whether the violence is directed towards a child or the child is exposed, the harm to the child, any compromise to the safety of the child, whether the family violence causes the child or family member to fear for their own safety. This is something I'd also like to touch on in a bit, just the fact that your own perception of risk is something that the court should be considering and giving weight to. Any steps taken by a person engaging in family violence to prevent further family violence from occurring and meet the needs of the child. This is another factor that I think is worth highlighting if you're a person who's been accused of committing family violence, or you believe that your partner has concerns around family violence. There are things that you can do proactively to satisfy the court that the risk is being dealt with or is diminished. And that's something that I think I'll bring up later on as well. So what is coercive and controlling behavior? The term coercive control often refers to a pattern of abusive behavior used to control or dominate a family member or intimate partner. Coercive control may involve acts of humiliation, intimidation, isolation, exploitation, and manipulation in the presence of absence of physical or sexual coercion. It's very insidious. It is ultimately really hard to define. This is one definition. In my experience, survivors often have a feeling when they hear about, when they hear words like this, they may start to feel like, oh, yeah, this is something that's happened to me. But it is otherwise very difficult to talk about. And it's of particular importance for self-represented people because it's so hard to talk about. It often, I think, gets missed when people are self-representing. They fail to bring to the attention of the court coercive and controlling behavior by their partner in a manner that would allow them to seek orders that would be a little bit safer and more appropriate for them and their families. Financial abuse is a kind of coercive and controlling behavior, and it's also something that I think comes up and is really difficult to manage when you're self-represented. It can include withholding funds. So often that means hiding assets, closing accounts, or transferring funds overseas. So draining the money from a joint bank account shortly after separation could be considered a form of financial abuse, leaving somebody without any assets to rent an apartment or, regain independence. Lifestyle. So during an intimate partnership, it could be discouraging work outside the home or making all decisions around spending unilaterally without the input of the other person. Debt, running up debts without the other person's knowledge or consent, or even taking out credit cards in the partner's name. Lastly, support non-payment. So refusing to pay child or spousal support, especially where there's an order in place requiring payment, is a form of financial abuse, and it can be treated as family violence. So family violence in dispute resolution. I want to start with this because often that's the first place people end up. Especially if you're working your way through the provincial court system, you may be arriving first with a family justice counselor, trying to resolve your issue without a traditional court process, which in many cases is a really good idea. It's a good thing to do. What should you be considering if you believe that you're a survivor of family violence, or you believe that family violence may be a factor in your case? The first is power imbalance. Family violence can impact a person's ability to negotiate fairly with another party. This is because mediation kind of creates or assumes a level playing field. This doesn't always have to be this way, but it often is. And I find frequently that whether it's a mediator or a family justice counselor, they may be in a big hurry to kind of smooth over the past so that they can focus on the future. So, wrongdoing in the past is less important. What do you need in place for your children to be okay now? And that is often productive because we don't want people to sort of just be stewing about the grievances that led to their separation. But on the other hand, grievances are one thing. Family violence or ongoing patterns of coercive and abusive and controlling behavior is another. And in my experience, that behavior doesn't diminish after separation. In fact, it increases. There's one study in particular, I think, that notes that a flashpoint for increased risk or violence to a survivor of intimate partner violence occurs about 2 years after separation. And that's because so much abuse is about control, about controlling the other person, about controlling the relationship. And when they feel a lack of control, a person with qualities of an abusive partner may then seek to establish that control through further abuse. And that's something to just be aware of in the process of mediation, that it doesn't always account properly for power imbalance. The second is trauma. Both alternative dispute resolution, whether that's meeting with a family justice counselor or hiring a mediator, may be traumatic. It may be traumatic to sit across from someone who's been abusive towards you and try to see things from their side, which is kind of a requirement of the mediation process. On the other hand, the court process can be traumatic. Although court has the benefit of giving you your opportunity to speak your truth, to tell your story, the court is not designed to deliver justice or fairness. It's designed to adjudicate disputes, and more often now, it's designed to move people through the system with some speed so that they can move on with their lives. And that means that your experience of violence may not be properly addressed by a court. Judges are, taking more training than they used to understand family violence, especially more subtle and insidious forms of family violence. But that is not necessarily going to be the case, especially, it depends on your judge or your registry. And so both processes can be traumatic. And I want to raise this because it's a good idea to think about not just about what process, whether it's mediation or going to court, what process is going to work for you in terms of what solutions you're seeking. But I'd also like you to consider what is going to make you feel more safe and what is going to address your needs for safety. And maybe that is alternative dispute resolution. Maybe that is a mediator, or maybe you feel safer just being in court on the record. These are things to consider if you are a survivor of family violence or if family violence factors in your case. The other issue is remedies. Alternative dispute resolution may not be able to address the financial abuse or other fallout of an abusive relationship where you need to gather evidence. And that's because the court process is an opportunity to, gather evidence, to request documents from the other party, to review their financial disclosure. And that doesn't always happen at mediation. It can happen if it's voluntary, and it may happen at a later stage. So for example, you follow a traditional court process to get those documents. And then once you have a clear picture of, the finances and how those relate to your legal situation, you might then say, okay, now I'm interested in mediation. But it's a good idea to just consider if your ex was the kind of person who hid things from you, who was dishonest, who wasn't necessarily forthcoming with information. Generally, people are in court and in the family process the way they were during a relationship. They don't improve. Lastly, collaborative options. Now, this is a newer process. There are some options for pro bono collaborative options that meet a particular, I think, not Mediate BC, but Pro Bono Canada, in partnership with the collaborative mediation roster, has put out a more affordable or a free version, but it generally does cost money. But collaborative options or a process that can sometimes reduce conflict and trauma, because both parties and their counsel agree that they're not going to go to court. They agree that they're not going to go to trial, and they're going to try to resolve things more amicably or more peacefully. But you're not alone with the other person. You have somebody who's advocating on your behalf, and there is some requirement that the parties exchange information, financial information, and other information to help them come to a solution. So it's just an option that you may think about if you're thinking about mediation or alternative dispute resolution, but you just don't want to be alone with the other person, or you don't feel comfortable sitting across from them with a mediator who isn't going to be on your side, is going to be trying to find, a solution that meets both of your needs, and that may mean cutting out your interests. So moving to the courts, what can a court do about family violence? The first is financial disclosure. So like I mentioned, requiring the other party to provide not just their financial statement, but information about their finances, money that they may have spent improperly. That's the first thing a court can do. And it usually happens pretty early on in a court process. The second is to order a Section 211. That's a report on the views and needs of the child. It can be a full 211 that looks at both the views of the child and the ability of the parents to meet the needs of the child, generally includes recommendations, or it can be a more restricted views of the child report, which is just a meeting with the child by by someone qualified to complete a 211, and they'll ask the child about what he or she thinks about a particular situation, or about being with one parent versus the other, what their needs might be, what they may have experienced. So if a child is making disclosures of abuse, or if you feel your child has been exposed to abuse, whether directly or indirectly, Section 211 is often one of the first things you might consider. Pardon me. You may have heard that Section 211s are extremely expensive. Private 211s are horribly expensive. I think it's a real access to justice issue. The fact that it can cost $10,000 to $20,000 for a private 211. In my experience, those 211s are, especially when performed by professionals working privately, they can be a risky sort of proposition for people seeking them. What I often recommend for folks who are looking to save some money is to seek a 211 by a family justice counselor who can do it free of charge. I think the waiting list is quite long for that, but it's free. Conduct order. A conduct order is an order for communication or conduct from the court, so the court can tell the parties, pardon me, the court can tell the parties to communicate by email only, for example, or to communicate only about issues relating to the child, or can actually control their conduct to a degree. So restrict them from making comments to certain third parties, or can make orders about how they will attend an exchange of children. So a conduct order, and I'll talk about this a bit more, is kind of not as severe as a protection order. It's pretty easy to get, but it can be limited in what it can accomplish, and I'll talk a bit about that. Supervised parenting time. So that's an order that parenting time be limited or supervised. That is an order the court can make, especially where family violence relates to a child. And lastly, a protection order. That's sort of the most severe option that a court can grant. And that's an order for protection of a family member, whether it is yourself or a child or both. And it does carry with it, even though it's an order that you are applying for in a civil court, a family court, it has criminal consequences. So I just want to provide some case examples. And this is to underline the fact that abuse is not just hitting. It isn't even necessarily psychological abuse in its traditional sense, but how family violence is understood in our court system is actually quite broad and inclusive. So for example, a father repeatedly using scripture to criticize and belittle the actions of the mother and children amounted to spiritual abuse. Derogatory and abusive emails went beyond mere bickering in another case and were found to be abusive. A mother repeatedly refusing to sign orders that were granted by the court or to allow the father access to the children pursuant to orders was found to be family abuse or family violence. And in a new case, Berendt and Greblinus, the court stressed the impact of family violence on children, whether the violence was directed at them or whether it was just violence that they were exposed to. And made a note that it is really quite hard to prove domestic violence allegations because they happen behind closed doors between private individuals. Some other case examples. Failure to pay child support with the intention to control and or harm the other parent was found to be family violence. A parent's intransigent and obstructive behavior relating to the sale of a property and to parenting arrangements was found to be a form of emotional abuse and harassment. And a father's demeaning remarks about the mother made to the child was found to be family violence directed at the child. So you can see a lot of these are coercive, controlling behavior. I think it's important to note how many of those relate to an unwillingness to engage in good faith or to engage abusively with the court process. And I think that's a good direction for the courts to be moving in, that non-payment of support, not following orders, is a form of controlling and ultimately causing harm to the other parent. So protection orders. Protection orders are covered under Section 183 of the Family Law Act, and they can be standalone applications. So this means that you can get a protection order from any court, whether it's provincial or supreme, and you can do it at any time, whether or not you have an open family case, or maybe you're like 2 years into your family case, you can seek a protection order at any time as a standalone order. If you're in Supreme Court, you can seek it in provincial court and vice versa. I mention this because the process in provincial court is a little simpler than in Supreme Court. It is less expensive. So on occasion, I've assisted clients in obtaining protection orders from provincial court, even where they had a Supreme Court file, because as self-represented litigants, they would have an easier time extending the order and speaking to it. The court considers whether family violence is likely to occur in granting an order like this, and it has a list of factors which it sets forth at Section 184 of the Family Law Act. And those are a history of family violence, repetitive or escalating nature of violence, whether abuse is coercive or controlling, the current status of the relationship, meaning are the parties recently separated? Are they moving through the court system? Are they separated for a very long time and live far apart from each other? Substance abuse, employment or financial problems, mental health problems where they would suggest an increased risk of violence. So it's not enough just to have a mental illness. Most people with mental illness are in fact survivors of violence, not perpetrators, but some forms of mental health problems might suggest an increased risk of acting violently. Access to weapons and a history of violence. These are all questions that you'll be asked if you were to apply for a protection order. A family member's perception of risk to the person's safety or security. Again, the courts have found that this is not just like a subjective perception. It needs to sort of be scaffolded by some of these other factors. There should be some reason, but the fact that a person fears for their safety and that fear is impacting their well-being is a factor that the courts want to hear about, that the courts will consider. And then any circumstance that may increase a person's vulnerability. So for example, in the past, I've argued that somebody being an immigrant to Canada and not having a stable immigration status and limited income was a circumstance that increased their vulnerability. They'd been dependent on their partner, were suddenly on their own. That made them more at risk of coercive and controlling behavior and other forms of violence. And that should be a reason to grant the protection order. A protection order generally lasts for 1 year, but it can be renewed. It generally can be renewed by application. It can also be made on an urgent basis, and it can be made without notice to the other party. So if you fear that seeking a protection order with notice, serving the other party with the application is going to result in an increased risk of violence, which often it does, you can seek it on an ex-party basis. And usually what that means is the other party can bring you back on relatively short notice to have a court review whether or not that protection order should continue. But in the short term, it can provide kind of that gap of important protection when leaving a partner or when moving through a flashpoint of increased risk of violence. Coming back to conduct orders. Again, conduct orders are kind of like the milder cousin of the protection order. In fact, sometimes when I've been in court in trial on a protection order, the judge has sometimes canvassed the parties. Would you be okay with a conduct order? Would a conduct order on the same terms as a protection order satisfy you? So if you're somebody who's trying to get a protection order moved aside, you want something a little bit easier to swallow, a conduct order may be a solution for you. On the other hand, if you find yourself arguing for a protection order and you think, geez, I'm probably not going to get this, you might consider a conduct order on the same terms as a plan B. Conduct orders provide a remedy where a person's conduct in litigation is contributing to the ongoing conflict. That's a bit of a softer kind of phrasing than violence. Conduct orders can limit communications, as I mentioned, often email, text message. My general position is that email is better than text message because nobody wants an abusive person in their back pocket, buzzing away at them. An email allows to set aside time to deal with those communications in a way that can kind of preserve and compartmentalize that communication as a separate part of your day. It can require parties to communicate positively and amicably. Often there are set terms that they must speak about each other positively and only on the issues relating to their case or to the children, must not share with their children anything relating to their family case. Communication restrictions have been found to be consistent with the charter, so people have challenged to say, well, wait, doesn't it violate my charter rights that the court is telling me I can't say the following things? Generally, as a conduct order, it's acceptable to do that. It may be made when a protection order, as I mentioned, would not be appropriate. The consequences are generally findings of adverse inference or a fine. So what that means is a court may take a look at repeated violations of a conduct order and say, well, I'm not going to give you shared parenting time because you're not following the simple terms of a conduct order. You're communicating abusively with your ex. You're not, you're trying to draw the children into the dispute, or they may even fine them. I've yet to see someone be fined for a breach of a conduct order. I'm sure it happens, but this is just to say, some people come back to me and they say, well, this conduct order is, not worth the paper it's written on. I would say it's worth the paper it's written on and maybe not so much more. It's not nothing. But I don't want people to think that it's sort of a panacea, that it's going to solve anything. And I understand the people who might be on this call who've had conduct orders granted and say, well, my ex didn't change their behavior at all. I'm sorry, that does happen a lot. Some case examples. The court ordered family counseling in one case. I thought that was really actually a great idea. Father was ordered to attend anger management and respectful relationships counseling in another case. More recently, communication has been restricted to Our Family Wizard, so not just email or text message. And I'm starting to think this is a really good idea because apps like Our Family Wizard also allow for a record of when pickup and drop off is happening. There's kind of a framework to actually talk about the issues relating to parenting of a child versus email, which doesn't have, it's just a blank page and your ex can talk about whatever they want. Court did not grant an order prohibiting a parent from making posts to social media in Bergevin. The court felt that it didn't really allow them to do that. But then in the AB and CD case, the court did make an order prohibiting a parent from speaking about his son's gender identity and gender transition to the media, though he was permitted to share his views with private individuals, friends, and family. So that was sort of that was the dividing line. So some tools and strategies. If you've experienced family violence, the first thing I want to recommend is accessing supports, and that can be an advocate. Advocates are worth their weight in gold. Lawyers have the fancy degrees on their walls and pay lots and lots of fees to the Law Society. Advocates, while they don't necessarily have those things, often have a lot of experience working directly with survivors of intimate partner violence. They often have an incredibly nuanced understanding of gender-based violence, and they also are plugged into a lot of non-legal, extra-legal resources that can help people after a separation. So the advocates that work for Battered Women's Support Services, ATIRA, organizations like Rise Women's Legal are extremely valuable resources. But even if you don't have those, or even in addition to those, a good friend or a family member can be so helpful in helping you gather the information you need and just to be resilient in weathering the trauma of the legal system that's not really designed for anybody, but least of all survivors of family violence. I often recommend people find a friend that is, not just, not just the you go girl kind of friend, but somebody that can push back a little bit and help you kind of, not just say yes, 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 but actually help refine your arguments and say, well, I'm not so convinced, but by that, because that can really help you present your best narrative to the court or to a finder of fact and adjudicator. Gather evidence and present it early, especially in affidavit form if you're seeking orders or a finding of family violence. This is just a general best practice for anyone who's looking for anything out of the ordinary when you're appearing for a family management conference. So that first appearance in provincial court, for example, putting some evidence of family violence or abuse that you've experienced into an affidavit can help the court sort of take note of that very early on. And that's especially important because in our current provincial court system, the court is really looking to grant, temporary orders that can stabilize things, move people through the system. And a lot of those orders don't take into account family violence unless it's brought to the court's attention. And I've heard from judges that it's not enough just for somebody to say, oh, I'm a survivor of family violence or he was abusive, but actually to present some evidence, some testimony, even if it's just their written testimony in affidavit form, so the court has something to kind of hang their decision on to justify making an order that would be more protective. Consider what process will be safest and most effective for you. Mediation, a collaborative process, traditional court. Don't necessarily assume that some process is better. Don't let somebody tell you what process is better. Really think about what's going to feel safest and best for you. You are the expert in your life, your feelings, your resilience, your strengths, where your strengths might lie. Consider what orders will keep you safer. So maybe a protection order is something that you want to seek before you start seeking orders for parenting time or spousal support or child support, so that you feel like you can ask for what you need without fearing retribution from your ex. Or maybe a conduct order is sufficient to kind of keep communication between you and your ex relatively civil while you try to work things out. And consider what arrangements might keep you safer around exchange of children. Exchange during parenting time is generally a flashpoint for abuse after separation. So, for example, exchanging children in a public place instead of at your homes can sometimes be a good idea. Or having somebody with you at exchange might be a good idea. So consider what can be placed in an order that would be protective and make exchange of children easier or safer. If you've been accused of family violence, gather evidence and communicate with the other party in a manner that allows a positive record. So in my experience, responding to family violence with angry emails or, well, here are the things you've done wrong often doesn't help. But remaining civil, remaining child focused is very powerful. It's a very powerful tool that you can then use. So making sure that the way that you're conducting yourself in recorded and stay on the record, don't speak face to face with your ex. If they are making accusations of family violence, send emails and make sure those emails are friendly and they're focused only on what needs to be done. Arrangements around property and arrangements around the kids. Consider whether you can agree to conduct orders or other arrangements that will make the other party feel safe and proceed by consent. Because if you're agreeing to a conduct order by consent that both parties will speak amicably, that both parties will communicate through our family wizard, that doesn't, incur any reputational damage. That's something that's being done by consent, by agreement, so that everyone is feeling safe. That's a way to be proactive. Per Section 38, take steps to prevent further family violence from occurring. So that may be if you have been accused of family violence and you feel like that is something that may have occurred, maybe it's regrettably you lost your temper, or there was a lot of hostility in your relationship and you acted out in ways that you're now thinking, I wish I hadn't done that. Going to counseling is something that you can display on the record, that you've proactively taken steps to address anger, that you've taken steps to learn about co-parenting. There are lots of courses you can take on co-parenting in a way that is child-focused and nonviolent. And generally being proactive in your family case. So figuring out what you should be paying in child support and making sure that that's paid, moving your case along towards a resolution that meets your needs and the needs of the other party is a great way to address these kinds of accusations. Because again, per Section 38, taking steps to meet the needs of the child, taking steps to reduce the conflict in the relationship is something the courts look very, very favorably on. In my view, sometimes too favorably, as someone who generally represents survivors of violence. But in the case of someone who's been accused of family violence, there are things that you can do to meet these accusations in a way that will result in healing rather than increased conflict. So general advice, this just applies regardless of whether or not you've experienced family violence, but this is a great way to prevent it or resolve it. The first is to keep a record of parenting and communication. So this is, I know I've said this more than a few times, but really, don't have phone conversations. I think people shouldn't text, because how often do we lose our phones? How often do we lose text messages? And how often do we shoot off a quick text at 3 a.m. that we then regret when it's shown to us in an affidavit in family court? So keeping a clean record of parenting and communication, keeping a journal of exchange, of parenting time, of childcare, really powerful. Those are things that can be introduced as evidence in court. Communicate as if there is a little judge on your shoulder. Every family lawyer will tell you that a huge part of any family trial these days is going through text messages or emails. So, even if you're freshly separated, just imagine, a judge might be reading this text message. Likely they will be. So do you want to sound like somebody who is child-focused, issue-focused, civil, amicable? Yes, you absolutely do. Do you want to send middle fingers? Maybe not. Maybe that's a bad idea. Whether or not it's justified. Don't argue, just state facts and position. This is huge. Don't argue. And I've had clients say, well, but what he's saying is wrong. But the reality is that if you are dealing with a person who's abusive, who has features of a high conflict personality, is another word we use in law, they just get jazzed up by arguing. You might have the experience, if you're a survivor, if you've been in an abusive relationship, that you'll be arguing with the person. You're getting exhausted because it's exhausting to argue with somebody. And it seems like they're just picking up steam. And that is often the case with somebody who has features of a high conflict personality. So arguing with them just doesn't work. It just creates long email chains that are frustrating to go through. What you can do is state the facts and your position. You can follow the BIF method, which is a method developed by a former lawyer and psychologist, Bill Eddy, who's written a lot on abusive relationships and high conflict parenting. And it's brief, informative, friendly, and firm. So keep your communications brief. I say no more than a paragraph. Informative. It should just be the facts, just what is so, friendly. Even if the other person is being a complete jerk, just stay friendly. It doesn't have to be sincere as long as it sounds nice in writing. And firm. So you don't have to necessarily cede your position. You can just restate your position. This is what I would like to do. This is the decision I'd like to make for our kid. And then you can end it there. So you can remain firm without necessarily getting drawn into an argument. And that generally will help you if you end up in court. And lastly, keep kids clear. This is especially challenging with older children that will sometimes try to involve themselves or that are just at a level of maturity. You know, if they're 15, 16, 17, they likely have opinions about dad or mom or what should be done, or they want to do this. And it can be very tempting to involve them. Just don't ever. And don't even give the impression that that's something that has happened. The courts really don't like it, and you can find yourself on the other side of, or you can find yourself on a judge's bad side very, very quickly, even for just a very minor breach of that rule. So those are just the general practices that I think everybody should be keeping in mind, whether you're not there's family violence in your case. So that is 7:03, not bad. I'm a little over.
All good. Thank you so much, River.
Yeah,
So we do have about half an hour for our questions. River, did you want to go through the ones for you first, since you just presented?
sure. Okay.
So let's see. We have a couple. So just a quick note to everybody, if we don't touch base on your questions, you're obviously welcome to send an email to us if you need more. But again, we can only provide legal information, no legal advice. So if any of your questions are a little too specific about your cases, we may not be able to touch base on them, okay? So, okay.
So I see a question from Julia.
Yes.
Any advice on how to deal with a husband who's falsely accusing his wife of harassment in an attempt to divert attention from the family violence? This is almost universal, I want to say, is that people who are abusive will often accuse the other party of abuse. And it's a problem because the courts really like to say it takes two to tango. That makes it easier for them to make orders. And because often it does take two to tango, not always, and certainly not in cases of family violence. I think in this case, just as a general practice, it's just clearly stating on the record what this person has done, making reports where necessary to law enforcement or the ministry, if it relates to children, if the abuse relates to children. Generally, I tend to discourage clients from making posts to social media or making comments to the media when they have an ongoing case. That's just my general advice. I don't know if that rises to the level of harassment. I haven't seen it, but I do think this is a problem. Sort of, sometimes the abusive partner is the partner that runs to court first and makes an accusation of family violence. So it's just stating your position clearly, and trying as much as possible to remain issue focused. And to remember, family violence, at least within the family court system, is not about punishing the other party, even if they really richly deserve it. But again, really focusing squarely on to what end are we going to achieve? What end are we looking to achieve through a declaration of family violence? The court in ABCD, that 2020 case in the Court of Appeal, found that just a declaration of family violence with no other purpose wasn't permissible. So there has to be some reason. Is it that there needs to be a particular parenting plan in place, for example? Or is it that there needs to be a protection order in place? So there needs to be some reason, and to just kind of stay issue focused, while also speaking truth within the framework of seeking those remedies from the court. Okay, that one looks like somebody offered a great read. Yeah, litigation abuse. That's that is by YWCA. That was some years ago. There's a great read that JAG shared on court-related violence and harassment. And since that was published, a lot of those cases have since come out. So the court is becoming more aware of the way in which the court system is used as a tool of harassment. I think RISE also put out a really great publication. RISE Women's Legal Center put out a great pamphlet some time ago, also talking about court-related abuse and harassment. It is an ongoing issue, but that resource is wonderful. And I'm not just saying that because they're my boss.
So a couple of the ones
an order
are, I think there's might be a little specific in relation to cases.
I will say, just somebody's asking about order for conduct. Conduct orders generally are granted in sort of on the way to something. So that's a weird way to phrase it. I'm going to rephrase that. Conduct orders generally are made in tandem with other applications. So I will often ask for a conduct order while I'm asking for a parenting order, while I'm asking for support orders. So it's not standalone. It's sort of, while you're asking for, a parenting schedule that you think is going to be appropriate, you can also ask for orders for conduct around communication. Protection order is a standalone thing. The only time that might arise is you've sought a protection order, a judge is saying, well, I'm not so sure about this. You might say, well, could I do this as a conduct order? But a protection order is a standalone application in a way that basically, well, I shouldn't say that. There's some urgent applications that are kind of standalone, not in the way that a protection order is. It's kind of special in that way. And you could seek a conduct order at any time. Exclusive occupancy order under the British Columbia Family Law Act for a rental house. That's a tough question. Exclusive occupancy is generally for a matrimonial home. I don't know the answer. I generally have only sought orders for termination of a lease for a rental property, and that can be done under the RTA. There's a form that you can fill out and serve your landlord to say, I've experienced family violence, and for that reason, I'm terminating my lease. So then you don't owe a lease obligation. It doesn't mean that you then need to move to a new property. And I acknowledge that in our current housing market, a lot of people who have rent tenure, they can't just move. Moving to a new property, leaving in a relationship where they've resided in a particular rental property could be financially disastrous. It's just another way that renters are at a significant disadvantage to property owners under our laws. If I cannot get a protection order, and the other side lawyer can ask you pay for cost. It depends. If you're asking for it in provincial court, costs are not paid in provincial court. Costs can be paid out in Supreme Court. So if you fail in an application, a judge could award costs in Supreme Court if you do not succeed in an application. Whereas in provincial court, costs are not payable. There are no costs. Is there a section of the Divorce Act or Family Law that addresses penalties that can be attributed to family violence when no orders are in place? The Family Law Act has provisions for extraordinary remedies that include fines. In my experience, generally, the court does not fine people unless they've warned them first. So generally, there has to be an order of some kind in place. Again, a finding of family violence is not really made in a vacuum. It's made in pursuit of some other end, whether that's a different parenting order or whether that's supervised parenting time or a particular division of property, for example, where financial abuse has occurred. But it generally just isn't made. And then there is a cause of action for abuse or for assault that can be made with a family claim. With a Supreme Court family claim, you can claim assault. I've done that only one time. So that is something, but that's not really a fine. It's essentially a civil cause of action that you're filing with your family claim. How can I make sure that he is not high or drunk while parenting time? Orders can include a requirement that the other party submit to regular drug testing. In terms of alcohol, that's hard to test for, but a drug testing can be made a part of a family order. How am I doing? Am I running out of time? I'm running.
No, you're not. No, I was just gonna add.
Yeah.
I was gonna add on to the orders. Isn't there an order as well that you can ask for that the other party doesn't consume alcohol or drugs, like illicit substances, like 24 hours or whatever amount of hours before parenting time?
Yeah, that's a conduct order. And I think KC was referencing that and was saying, like, how can I make sure that he is not he's abiding by that? And that's a problem with conduct orders generally. It's not always easy to know if the person is going to follow it. In the case of drug, you can do a drug test. I don't know how you test for alcohol, but I will say that I have had cases where the other party has shown up for exchange and they've smelt of alcohol. And that's been cause for the person to withhold parenting time in that case. Justifiably, don't withhold parenting time as a general rule, or unless you have extremely strong evidence to that effect. But that's just an example. AA sessions, yeah, if anger management counseling, those are all things that have been ordered in conduct orders. And I think, I actually think it's a great idea to order any, training or counseling that might be supportive of somebody with substance abuse issues that impact their parenting, whether or not there's family violence. Counselor provide us with a letter of observation. Yes, I've had counselors. I've either had counselors provide letters. I've also had counselors provide testimony about the experiences. Counselors and social workers provide testimony about the experiences of a person who's a survivor of violence. So it may be a good idea to reach out to a counselor if you've worked with a counselor, and they could speak to both the family violence that you may have experienced, or they may also be able to experience have something to say about the impact that that's had on your well-being. Yeah, somebody mentioned affidavit from my counselor as part of my case. Yeah, or a letter that gets put into an affidavit is also quite helpful. Conduct order isn't necessarily time limited. It's technically an interim order, but conduct orders don't have that year expiry date that a protection order does. And the reason why a protection order is generally time limited, in part, well, the main reason is that it is quasi-criminal. It's kind of a rare thing. Everything else in our system, you might get a fine or you might lose parenting time, which is pretty terrible. But a protection order is the only civil document I know of that can result in someone seeing the inside of a prison. So because of that, the courts want to be really, really sure that it's a necessary step. And they also want to know when it's going to expire so that the person has some awareness of when they're actually under the terms of a protection order. And they'd like to check in on a yearly basis to see if that kind of severe order is still necessary, if there's still an ongoing risk of violence. Jag is saying the person in my case had to provide drug test every month. Yep. I've seen those orders. Is it okay to expose the other party's emails through an affidavit containing financial abuse, hiding assets of both spouses? To an affidavit containing financial abuse, hiding. Yeah, I mean, so this is getting, Emily will rightly say I cannot offer specific advice. And of course, I don't know your case, but a big part of exposing financial abuse, which is actually quite hard to expose, is when the other person the other person has an obligation to provide all financial disclosure necessary for a court to make a full decision. And if you have evidence that the disclosure that they've made is incomplete or is not truthful or is hiding information, it's always a good idea to bring that to the court's attention. And where the court has a finding that the other person has not provided full disclosure, they will make an adverse inference and will take circumstantial evidence like emails to make a correct decision. So, I've had cases where, for example, somebody was earning money under the table doing construction work while claiming that they were on social assistance. But then I had Instagram posts from that person, showing dollar bills and showing a lifestyle that didn't fit with what they were claiming. And I was able to establish that they were not on income assistance, but were actually working in construction. And then the court sort of had to figure out, well, what could they likely be making? So that's to say two things. One is circumstantial evidence is very valuable. And two, don't do that. Don't whatever you're making, because it can end up actually hurting you quite a bit. The best thing you can do, no matter what side of this you're on, is to provide the court with all of the information that they need to make the right choice for you and your family. And not doing that can be family violence. Contempt order is another one that can result. That's true. A contempt order contempt is a hard thing to get again, but it can happen. It can happen. I generally am hoping that conduct orders, fines, and judges looking really angry will be enough to have people behave properly. I realize that is Pollyanna. Okay, I think I made it to the bottom of the list.
Yes. Thank you so much, River. We really appreciate you and all the speaking you did today and all the questions you've answered. I think there's a couple for Emily. Going back to the fee waiver. So just a quick question from KP about the fee waiver. Does that also include when the documents charged for swearing at the registry?
That's a good question. So my answer is, like anyone in law will tell you, it depends. It's just like the boilerplate answer for things, but it can, yeah. If you're asking for all of your fees to be waived, it can. But if you're only asking for certain fees to be waived, or if the judge only says that certain fees should be waived, then the answer is no. So it really depends on what the actual final order for like the fee waiver is and what it contains, if it has any exceptions or things like that. The other thing that I just want to point out is that once you get that order, it's important to bring it to you whenever you go to the registry to file something, swear something, whatever it might be. Make sure that you just bring a copy of that signed order with you so that they know that you do have a fee waiver.
What about the assets in section for the Form 86? Do all family assets need to be included even if they do not have control of them?
Okay. So even if you don't have control of them, no, it would be whatever assets that you have and have an entitlement to, if that makes sense. So if you're have a match, like if you have a family home and you and the other party are both on that family home on title, you both own it, you would want to list that as a family asset. You might just want to note that you own half of that house. So you would probably put down maybe like half of the value of that. But if you don't own it, say it's the other party's car, and sometimes you use that car, but they actually own it, then no. It would just be things that you actually own or have as assets yourself. Of course, so if I'm wrong here, somebody please jump into. That would be fine as well. How about gold and jewelry that my parents gave me when I was 15 years old? I've gotten this question a lot. How about jewelry? Again, it depends. Usually, if it's not really that significant, and you can't really put a value on it, it's not really like something that most people would put on a fee waiver application. If you're doing a financial statement, that's a different topic. These are different than financial statements, so you have to keep that in mind. A fee waiver application, Form F86, is going to be a lot more casual and less precise. So just because I'm saying, oh, you might not want to put, like, that might not be a huge factor in a Form F86. For a fee waiver doesn't mean that you should include it in a financial statement. So those are two different things, especially when it comes to jewelry and gold and things like that. So I'd say it depends on how much jewelry you have and what it's valued at. Yeah, but generally, if it's just like a small thing, like, you have a gold necklace or whatever, that's not generally something that people think of when they're putting it on a fee waiver application.
Perfect. And we will be going over in week 8, November 7th. That's where we're going to touch base on financial statements. So that's the different one, form the F8, not F86.
That one's much more specific, and that's something
Yes.
that you want to put on that form. But for a fee waiver, maybe not. Is there a relationship between a fee waiver and court costs? No. The fee waiver is going to be in relationship to what your income is and what your expenses are. Yeah, I mean, and by court costs, I'm assuming that you mean fees for filing and like so fees that are in Appendix C of the family rules for Supreme Court, not costs as in penalties in court or costs awarded against you. A fee waiver will not waive costs awarded against you if you lose in BC Supreme Court. If you make an application and the other party comes out successfully and they award costs against you, that's not going to, like a fee waiver is not going to exempt you from that. But in terms of, court fees, filing fees, storing affidavits, getting certificates, things like that, like administrative fees, there's no relationship. It's more so in relation to whether or not you meet the test for undue hardship or if you're receiving benefits. How does the presence of a fee waiver affect the costs? Yeah, so that's same thing. It's not going to exempt you from, a penalty against you. Those are a different sort of cost. Will register, yeah. Does having a fee waiver impact the fees associated with expert reports? No, so an expert report is something that you pay to the expert a lot of the time. It's not something that you pay to the court. So whether or not the expert wants to charge you and how much they want to charge you, it's more of like a private service. Then that's going to be that. The fee waiver will not unfortunately impact that. But again, like River was saying, like there are a lot of options to get some kinds of expert reports for free, like for example, a Section 211 report about children. You can go get that for free from a family justice counselor if that's something that you want to get or you have an order to get. If my JCC is scheduled first for my FMC and I have a lawyer, can I apply for a fee waiver? I only have a lawyer because I'm digging in a line of credit. This is a tough one. If you are privately hiring legal counsel, it could be a toss-up. It could be a toss-up because that's going to be a lot more expensive than filing fees, for example, right? Like filing fees are a few $100s. Hiring a lawyer is probably a few $1,000s, if not more. So if you're choosing to spend money on hiring private legal counsel, a judge might look at that and say, well, why should we waive your court fees when you're deciding to spend money on thousands of dollars on legal counsel? So it really depends. I'm not saying that you can't apply if you want to. You can. It's just different judges might look at that different ways, especially if you're claiming undue hardship and you're not receiving government benefits.
I think that's all the questions that we had for fee waiver. Yeah, perfect. Okay, thank you both of you, Emily and River. We appreciate your time, and everybody, we appreciate you coming in tonight. We will be having our next session. So next week is our research session on Tuesday, October 17th. That's week 6. So reminder, that's at 5:30. We will see everybody then, and we will log off a few minutes early.
Oh, hold on. Somebody actually popped a question in last minute, I think. Hold on. Should I apply before or after? I'm not sure what that means. I don't qualify for benefits. You can apply for a fee waiver at any time if that helps in the process. Usually, of course, most people apply sooner rather than later because you'll save more fees. Yeah, you can apply for a fee waiver whenever, unless, I don't know. Yes, that's what I think.
Okay, perfect. Okay, thank you, everybody. Okay, good night.
Good night, all.
Rachel?
Hi. Somebody's talking? Oh.
Hi, I know we are being recorded, but if you were to stop the recording, is it okay to mention something?
It depends on what that thing is what I'm going to say. And I'm going to say if I have to stop the recording to do that. The answer is probably no, because I feel like it might be very private and not something that should be discussed on Zoom with other people present. Sorry about that, but if you do want to email us, we do read all of our emails and reply to all our emails. So if there's something you'd like to share with us that way, that might be a better way to do that. Oh. Okay. Yeah, unfortunately we don't give out private contact information for our speakers just because we have safety concerns and we've had safety concerns in the past, but we can pass any questions you have directly to the speaker and they will be able to get back to you if they feel like it's appropriate to respond with their personal email or something else like their work email. They will do so, but otherwise, yeah, we try to keep everything inside of our info at litigantschoolbc.ca or .com email address. But we'd be happy to pass it on if you do have a question for River.